Defense, you may proceed.
Well, Judge, when we begin with our motion to suppress, we believe that the central issue here is not the warrant, so to speak, but that the state's primary evidence comes from a secretly recorded attorney-client conversation between Ronald and his former lawyer, Mr. Ireland. The conversation occurred in a confidential legal setting during a time of high emotional stress on the part of my client, and in a context where Ronald was actually seeking legal advice and not making public threats. We argue that the recording should be suppressed for two real core reasons. First off, there's a breach of confidentiality and the attorney-client relationship. So even if Mr. Ireland is a party to the recording, this was a protected consultation. The decision to record, share, and weaponize that conversation violates the principles of trust and candor embedded in our legal system among lawyers. The second reason that we think that the recording should be suppressed is because the resulting statement, it lacks reliability. The state offers a paraphrase.
All right, counsel, just 1 second. If we can start with, you're saying that there's an attorney-client privilege that's been violated by the attorney?
We believe that.
Okay.
The reason for that is there's disciplinary rules regarding attorney-client confidentiality privileges, but we do know that the complaining witness in this case had a contractual relationship with Ronald Allen and that he was his divorce and custody lawyer. And this conversation, according to the state's evidence, my client and all other indications occurred in that attorney's office in a confidential setting, and it was recorded without the knowledge of Ronald Allen. And we believe that it was weaponized by the attorney because of a contractual dispute, because of problems with the representation that were occurring, that were being discussed in the recording that is in the state's evidence, the state's discovery.
So with regards to your stating that this was some sort of attorney-client privilege, unless someone is going to stipulate that there was a conversation that was had between your client and the fact that your client had this conversation with his then attorney, Mr. Ireland, and that during that representation, there was a conversation between the two. Is somebody going to stipulate to that?
Yes, Judge. By the end of today, if the state has their witness, like they say they do, we believe that Mr. Ireland will testify, and he's the complaining witness on this case. That's our understanding.
So who is calling the witness?
The state does have two witnesses ready, and even though there wasn't a warrant or there was and burden has shifted, the state has our witnesses here, and if defense wants to call our witness and then have him available to us on cross, he's available.
All right, then defense, because there was stipulated that there was a warrant, then the burden does shift to the defense. So what witness would you like to call?
Let's call Mr. Ireland. Charles Michael Ireland.
Okay. All right, I recognize you as an officer of the court. However, if you could raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can have a seat. All right, if you'll state your name for the record.
Charles Michael Ireland, Jr.
All right, you may proceed, defense.
Mr. Ireland, were you Mr. Allen's attorney during a portion of his family court case?
Yes.
You made a recording of a meeting that you had with him. That meeting where the recording was made, that took place in your office. Is that correct?
Your Honor, leading.
Sustained.
Where was the recording made?
In my office.
All right. Do you know if Mr. Allen believed he was speaking with you in confidence because of the contractual relationship you had, or did you have some other arrangement where you had already told him that you were getting off the case?
Objection, Your Honor, speculation.
Sustained.
Why was he in your office?
I believe that's attorney-client privilege.
And so the conversation, you would agree that the conversation that you had with Mr. Allen was attorney-client privilege, correct?
Yes.
Well, that's all I have for right now, Judge. I'd like to pass the witness.
All right, state.
Your Honor, may I approach?
Yes.
I am showing you what has been pre-marked as State's Exhibit 1. And what is this?
It's a recording of the conversation I had with Mr. Allen.
What date did that happen?
I believe it's April 21st, 2025.
And are your initials anywhere on this?
Yes.
And is there a date associated with your initials?
Yes.
What date is that?
Today's date, July 28th, 2025.
And when you listen to this Was it an accurate portrayal of the events that day as you remember them?
Yes.
Was it altered in any way?
No.
Your Honor, at this time, state moves to enter State's Exhibit 1 for purposes of this hearing pending inspection by defense.
Yes, I see that, and that's been provided to me.
Any objections for
No
purposes of
objections,
this hearing?
Judge.
All right, State's Exhibit number 1 is admitted for purposes of this hearing.
You on direct stated that you agreed the conversation was attorney-client privilege. Is that true?
Yes.
Did you believe the entire conversation was attorney-client privilege?
No.
What sorts of things are not privileged under that attorney-client privilege?
Mr. Allen said some things to me that I believe clearly established that he was going to attempt to or commit an act that would cause bodily harm or worse to one or more individuals.
Do you recognize Rule 503 to be the rules of evidence for attorney-client privilege?
Yes.
And in that rule, there is an exception. That's true, right? There's multiple exceptions.
There's multiple.
There's an exception that says the privilege does not apply in furtherance of a crime. Is that true?
If you say so.
Well, in this conversation that we're about to hear, something alarmed you. Isn't that true?
Yes.
And you believed that the attorney-client privilege no longer held because of that statement.
I believe that because of what was told to me, I had a mandatory duty to report it to authorities.
But something is going to happen that is going to change history. You bust these guys or there's dead bodies everywhere, bro. What did you take that to mean?
I believe that was a threat that if he didn't get what he was seeking, that people would be hurt.
You're familiar with threats like these. That's true.
Yes.
What do
Be a real true threat.
in the recording we just heard at 57 seconds, defendant says history is going to be made on Wednesday. Tell us the significance about that Wednesday date.
That was the date we were set for a temporary orders hearing. Mr. Allen had up until that point
How defendant came to be in your office.
he just showed up.
Had he spoken with anyone before speaking with you in your office?
I think he met with my front desk receptionist.
Why did you accept this interaction with defendant when he hadn't had a planned meeting with you?
I had availability in my calendar. I had about a half hour to 45 minutes available, if I remember correctly. And I knew he was anxious about the hearing, and so I thought I'd give him some of my time to hopefully make him.
For Wednesday, something is going to happen that's going to change history. Bust these guys or there's dead bodies everywhere. Who was the first person you called after that?
I called the State Bar Ethics Hotline.
What were you advised?
I had a mandatory duty to report what was told to me to law enforcement under Rule 105E of the Texas rules of the disciplinary rules for attorneys the ethical rules that we live by.
Why did they say you had an ethical duty to report?
The State Bar Ethics Hotline believed it met the standard in 105.
Anyone else?
Yes.
Who?
My attorney, Carl Cobb.
Report. You told Lopez your fear of the threat that there were going to be dead bodies everywhere, right?
Yes.
You did not tell Lopez anything about any attorney-client privileged information.
No.
The recording we just heard, its total duration is 12 minutes, 54 seconds. It was at 10:45 that defendant said there's going to be bodies everywhere. How did you respond to that statement?
I was in shock. That was the second time he had said, we're going to make history on Wednesday. And I think at some point, even in my head, I said, don't say it. And then he said it, that there would be dead bodies everywhere. No.
How about in the near future?
I arranged for my office to have active shooter training and also paid for my entire staff to be trained in handgun shooting.
You would agree with me that throughout this 12-minute 54 conversation, you agreed with a lot of defendants' statements and paranoia. Isn't that true?
I don't know that I agreed with the paranoia. I had felt like up to that point that Ronnie had gotten an unfair shake in the civil courts.
You had mentioned when defendant
So that statement was because I thought, like I said, I thought he was getting an unfair shake in the civil courts based on my experience with Mr. Allen up to that point.
when would dead bodies be everywhere?
I presumed based on the subject matter of the conversation, it would be on April 23rd, that Wednesday at the hearing.
At 57 seconds, history is going to be made on Wednesday. You remember defendant saying that?
Yes.
6 minutes, 52 seconds. I know Wednesday something changes in my favor. You remember that?
Yes.
10 minutes, 45 seconds. I'm prepared for Wednesday, but something is going to happen that is going to change history.
Okay.
Do you know what this is?
Yes.
How do you know what this is?
This is the transcript of a hearing, well, the part of the final hearing for Mr. Allen's protective order.
What date does this have on it?
June 23rd, 2025.
What court does this have on it?
Well, the case is filed in the 150.
What was this hearing for?
That was the continuation of the final protective order hearing that Miss Allen had filed against Mr. Allen. And I testified that day.
There was discussion about a motion to withdraw, though, wasn't there?
Mm-hmm.
And when asked about that motion to withdraw, you told the court that the defendant made a statement that you reasonably believed, led you to believe that the defendant was going to commit a crime that would result in the death or substantial harm to another person. Isn't that true?
That's true. He seemed very agitated. He was sweating profusely.
Were you scared in your office during this conversation?
Over the course of the conversation, I became more and more anxious.
When defendant said there will be bodies everywhere, were you afraid for your life?
Yes.
You were afraid for your staff's life?
Yes.
You were afraid for the lives of the people at the courthouse?
Absolutely.
You were afraid for defendant's family's life,
Yes.
to specifically include the children,
Yes, his son, Aiden.
the child, and the ex.
He said something was going to change. And when he made the statement, dead bodies everywhere, after he said he was going to make history, that specifically.
You mentioned playing the recording for your staff. That freaked them out, didn't it?
Yes, they were all very concerned.
Objection, hearsay.
Right, that'll be sustained.
Your Honor, the state kindly passes the witness.
All right, defense, you may proceed.
And the lawyers weren't taking this matter serious enough. I think family cases are because of they're toying around with it, and I think that there's dead bodies everywhere because of it. Every family situation, murder suicide I see on the news was related to a family dispute gone out of control, and that's what I was
the defense's argument is there's no probable cause. You may address that, counsel.
Judge, regarding we did hear testimony from Mr. Allen, Officer Che, and Attorney Ireland. We heard Attorney Ireland's recording. We'd seen the state's theory take its full shape. There's a lack of criminal conduct, dead bodies everywhere. But when we heard the recording, that phrase was never heard by the court in the recording submitted by Mr. Ireland and played for the court. The actual statement made by Ronald was, quote, "So if I was going to do that and I knew all this stuff was going to happen, period, I'm prepared for Wednesday." But something there's going to be dead bodies everywhere. Now, our contention is that neither of these statements includes an assertion of personal action on the part of Mr. Allen. There is no named victim, there is no identified target, and there is no expressed intent to carry out any kind of violence. It's also troubling that the DA's office or Detective Che did not fully review the audio, but simply adopted Mr. Ireland's paraphrase as fact.
All right. And with regards to no complainant being identified, is there really a need for a complainant to be identified if there's a threat? And I'm not saying it's a threat. These are just questions that I have, Mr. Allen. Is there a need to identify a singular person if there's an alleged threat?
In the recording that we heard, none of those public servants are specifically targeted. This statement has been taken out of context. He's not particularly naming that he's going to do anything to the court. Or to the courthouse or to any of the people that work here. I'm also, I think you should know, I've been practicing 15 years. Mr. Allen's testimony reflects a constitutional innocence to him because he testified that he believed he was speaking confidentially with his own lawyer. He had no intent to harm anyone. He was not emotionally stable at that point because of
Do both parties stipulate that a client's conversation with his attorney in a legal capacity is confidential, that that's the bar? Do both parties stipulate to that?
The state understands that confidentiality bar is there with exceptions.
Exceptions, yes. Is there an exception?
Where?
All right. And defense, do you stipulate to that?
Yes, Judge, we do know that there are rules. Rule 105C7 of the ethics rule provide for permissive disclosure to prevent criminal acts. And we anticipate that Ireland would be arguing in likelihood of harm must be waived, the threat must appear imminent and grave, and the disclosure must be no greater than necessary. The problem here is that Ireland disclosed everything and voluntarily handed over a recording, and that recording was not narrowly tailored as a warning. And then we have his own testimony. It's a reasonable belief of a grave and imminent harm. He continues to try to expand and express that he's in deeper fear than he was in the moment. And I think that's a vital distinction, because if there's a terroristic threat, I think that his action should be immediate. But rather, what Mr. Ireland did, he didn't immediately call 911. He immediately was going to favor him making this disclosure, at least to mitigate the immediate harm. But I think on retrospect, after 100 days in jail, the harm and the potential harm has been mitigated.
All right, so let's start here. The first thing, the court finds through stipulation, and I think both parties know, that when someone is speaking to their attorney, is if there is a threat of future criminal activity, or is it if there's a threat of harm to anyone else. So let's start. State, do you want to address whether or not the communication that was testified, that is the basis for this alleged offense?
Express or implied intent by saying, if X does not happen, then Y is going to happen. If X, I don't get my custody, then Y, there's going to be dead bodies everywhere. That is both express and implied. Express, dead bodies; implied, maybe the how. Those privileges are to ensure fair trial, trust between
Court is going to find that there has not been a violation of the attorney-client privilege under the Disciplinary Code 1.05C7. Now, the next thing I want to talk to you all about is whether or not the communication to his attorney that we're here for, whether or not that's protected speech. And that's a part of
Reporting and in what was discussed with Mr. Ireland on the stand, there are a number of statements that Mr. Ireland stated that tend to show that at the moment, Michael Ireland was not afraid. His own words and conduct tend to prove it. What we think is that Ronald Allen's testimony reflects constitutional innocence because Mr. Allen had been recorded. When we get further into this, Ronald also expresses his own fear in the recording because he says, "I'm scared for my life, dude." That's not the speech of a would-be assailant. It's the language of a man trying to make sense of what he perceives as an unjust legal system. In my motion, I mentioned a number of cases, and one of them is the Watts case. Old draft dodger made the following remark, quote, "If they ever make me carry a rifle, the first man I want to get in my sights is Lyndon Baines Johnson, LBJ." This, by the Supreme Court, was interpreted as a threat. This was interpreted as a threat by the authorities under the and not a true threat, and therefore was protected speech under the First Amendment. This applies because the context matters. True threats are not protected speech, but the government must prove that the speaker intended the statement to be understood as a serious expression of intent to reference to Ronald's case, this also was a vague and conditional statement. It was delivered in a nonviolent setting, and it was interpreted literally by the government, despite clear indications that it was a figurative rhetoric involving custody. There's another case, more recent in 2015, the Alanis v. United States case, where the Supreme Court held punishing threats require proof of a mens rea or a subjective intent to threaten. The Alanis case holds that a person cannot be convicted based on how others might perceive their words. Rather, the speaker must actually intend manipulation, and emotionally charged grievances, where at one point Ronald even says, I got called into jury duty the same week in the same courtroom. The odds of that is like me winning the lottery 20 times in a row. Bro, it didn't even happen. He further elaborates, hey, I had jury duty, dude. They asked me certain questions and they made me sit there all day. The same effing judge. They wanted to know what I knew and if I recognized those other two girls. When I read these statements, they don't seem to be statements of intent. They're statements of subjective fear, suspicion, and confusion. And it's exactly the kind of talk one might share only with their lawyer while trying to process whether the system is fair or rigged. Here, far from planning any violence, Ronald was exploring whether something conspiratorial was happening to him, and he was seeking his lawyer's validation and advice. In the same way in Alanis, the court emphasized that convictions under federal threat statutes require subjective intent. So the speaker must actually have intended the words to be understood as threatening. In that case, the court reversed a conviction that was based on an objective, reasonable person standard, and holding that omitting a reference to intent in a criminal statute does not mean that the mere negligence is the appropriate mental state. So here, we might agree that the words that Ronald used in his lawyer's office were negligent because they might be interpreted as a threat, but his intention
Isn't whatever your client's intent, that's something for a jury to decide? Or if this were a bench trial, then it would be for me to decide. But based upon your motions, what you're here for is whether or not there was a warrant issued. It's been submitted that there was a warrant issued. Both parties stipulated to that. Whether or not the communication with his attorney was privileged or not. I'm finding that the communication was not privileged because it falls under the exception of a threat that was being made. So the threat that was being made, that wasn't privileged communication. Now, whether or not Mr. Allen, whether or not you meant that, or whether or not it was intentionally, knowingly, or whatever the mens rea may be, that's something.
On June 24, 2025, defendant Ronald Allen was charged in the 187th District Court in Bixar County with making a terroristic threat after prosecutors alleged that he threatened mass violence during a private meeting with his former divorce attorney, Charles Michael Ireland, Jr. The state's case centered on a secretly recorded conversation in which Allen stated, "I'm prepared for Wednesday, but something is going to happen that's going to change history. Whether you bust these guys or there's dead bodies everywhere, bro," which Ireland interpreted as a genuine threat tied to an upcoming custody hearing. Allen's defense attorney, Charles Butcher, argued that the recording violated attorney-client privilege, that Allen's remarks were emotional venting rather than a true threat, and that the statements were protected speech under cases such as Watts v. United States and Alanis v. United States. Prosecutors countered that Texas disciplinary rules created an exception to confidentiality when an attorney reasonably believes a client may commit violence causing death or serious bodily harm. During the hearing before Judge Stephanie Boyd, Ireland testified that Allen's behavior, repeated references to making history, and comments about dead bodies everywhere caused him to fear for his life, his staff, and people at the courthouse, prompting him to contact the State Bar Ethics Hotline and law enforcement. Judge Boyd ruled that the statements fell within the crime fraud and future harm exceptions to attorney-client confidentiality, denied both the motion to suppress and the motion to dismiss, and held that whether Allen actually intended to threaten anyone was ultimately a question for a jury. Before trial, however, Allen entered a no-contest plea and received 5 years of deferred adjudication community supervision, avoiding a formal conviction if he successfully completes probation.